Okay, it's 7:05 in Alaska, and this is Free the People. And tonight we're going to talk, we've got two distinct topics tonight. The first one is how to bring forward your land patent, and the second one is in regards to the implementation of the Noahide law. And so just wanted to let people know by way of announcement that we did receive the books in from Ron Gibson, and we got together in up in Fairbanks this last week and distributed the books to everyone who had ordered them. And so now we've got a little bit of time to go through them, and before too long we'll let Ron Gibson know. I called him the other day and haven't heard back, but we'll get him on the call to help us with our individual questions once we've had some time to go through the books. I wanted to let everybody know also that after tonight, if you're more interested in getting the book, I'll give you the address on how to order it near the end of the call. But I would recommend that everybody go to Northwest Liberty News YouTube channel and pull up the Ron Gibson seminar on land patents, because really he goes through a good amount of what's in his book in that seminar. And so if you're interested in being a landowner and establishing yourself as one of the people of the several states and reestablishing yourself as one of the founders of this country, you'll learn a lot about how to do that as you go through that seminar. And I'd encourage everybody to do it. And I think this is an important underlying issue as the assemblies are established. It only takes a little bit over 61 days to do it. I think we have 61 days left before too much goes on at the global level. And I think this is going to be an important thing for people to do, and strongly encourage you to do it. By way of review, the most interesting thing I read in Ron's book so far, and I've been through about half of it now, is that if you fail to bring your land patent forward and fail to accept the conveyance that is the land patent, you've given up your common law rights. So you basically are operating solely in the commercial jurisdiction as far as the land goes, and you can't expect to stand up on your common law rights. Over the last few lessons, what we've done is basically explained what the lawful basis is for these land patents and the purpose of them and what they are and why they are. And Ron explains in his seminar that when you bring the conveyance forward in your name, what you're actually doing is removing this parcel of land from the commercial jurisdiction and putting it back into the land jurisdiction. So that makes perfect sense that this is why your common law rights can be upheld now, that you've moved it back into a different jurisdiction. So there was one more small point that I wanted to mention that I learned from him in that, and by watching the seminar. And one of the things that I'll say that I do recall right now is that he says that having a land patent is evidence of your sovereignty. And as I read through the book, in fact, there are court cases that happened within the United States, within some of the states and the Supreme Courts of the states that seem to uphold that idea. Yeah, and I went through some of the court cases. There are loads and loads of court cases in this book. And I remember reading that particular thing, that it was prima facie evidence of the status of the man who's got a land patent. If you just think about the Lockean theory that your land is evidence that you are sovereign. Owning your own land is evidence of that. A couple of the court cases that I will read include Close versus, difficult to pronounce this name, Stuyvesant. It was clearly the policy of Congress in passing the preemption and patent laws to confer the benefit of those laws to actual settlers upon the land. The power and dignity given to the patent. These cases all illustrate the power and dignity given to the patent. It was created to divest the government of its lands and to act as a means of conveying such lands to the generations of people that would occupy those lands. And further, in that case, the patent was and is the document and law that protects the settler from the merciless speculators, from the people that use avarice to unjustly benefit themselves against an unsuspecting nation. The patent was created with these high and grand intentions and was created with such intentions for a sound reason. The settlers, as a rule, seem to have been poor persons and presumably without the necessary funds to improve and pay for their land, but it appears that in every case where the settlement was made under the preemption law, the settler entered and paid for the land at the expiration of the shortest period at which entry could be made. And then in Miller versus Little, in furtherance of what is deemed a wise policy tending to encourage settlement and to develop the resources of the country, it invites the heads of families to occupy small parcels of the public land. To deny Congress the power to make a valid and effective contract of this character would materially abridge its power of disposal and seriously interfere with the favorite policy of government, which fosters measures tending to a distribution of the lands to actual settlers at a nominal price. So we went through some of the rationale for this over the last few meetings. We talked about the fact that your rights can't, well, first of all, we talked about succession of laws from King Alfred in England in about 871. All the way up through Magna Carta, all the way up through English Bill of Rights, up through the Declaration, up through Northwest Ordinance, and all the way up through. And the fact that your rights can't be abrogated by succession of law. Not something that we have to have firmly in our head. Then we talked about the Reformation and people coming to this country in order that they would own their own lands. And that kind of brought us into the resolution of 1780. Last week we talked about the resolution of 1780 and how that gave rise to certain clauses in the Constitution. And one of the most important ones is that Congress shall have the sole power to make needful rules and regulations regarding what was going to happen to these lands that were placed into the trust compacts when the original states gave their lands, their western wastelands, into the trust of the United States, and the purpose of why they were giving those lands into the trust. So what we found out is that the resolution of 1780 gave rise to more states putting their western wastelands into the trust compacts after the example that had been done by New York State. And then this gave rise to the various clauses in the Constitution of 1788 that took effect in March of 1789. So that was Resolution of 1780, if you're looking for a keyword to search on and find out about what that was and what they said there. Then actually we did this the week before, or 2 weeks before, we talked about the various acts of Congress from 1776 to 1862 that gave rise to the various 11 types of land patents. And so we've kind of come through so that everybody has a real solid idea of the foundation of all of this law, so that as you go through and you bring your land patent forward, you need to know that you're on solid ground. And you need to know that not only not only was this land issue important all the way through time, and it was one of the basic foundations of our principles of our country, but it was also then reaffirmed over and over again by courts of the United States and courts of the several states. And if you have it clearly in your mind that you're not going to have your rights abrogated by succession of laws, some of the subsequent acts of Congress that have happened may appear to have taken away our rights to own our own land, but we need to bring forward these old laws. We need to stand on the old laws so that we're not going to basically be pushed around on it. So that's the purpose of painstakingly kind of going through these things one by one. If you missed those shows and you're interested in going back through, we ran through all of that history fairly quickly, so it's not horribly long, but those shows are on YouTube on my channel, and you can go back and kind of listen to those shows about what the acts of Congress are, what the 11 types of land patents are, what the clauses in the resolution of 1780 are, and how those gave rise to certain clauses in the Constitution, the original Constitution. And I started to say the most important clauses seem to be the I can't think of it what they call that clause, but it's the one about Congress shall have the power to make needful rules and regulations in regards to how they divest the land out of these trust compacts. So that's important, and very important is the oh darn it, I can't remember the name of that clause either, but it's the one that says that we should all be admitted it's the one that gave rise to the equal footing doctrine. Might be the equal footing clause, in fact. I'll get my book and check it out. But anyway, the point is that anytime a state is formed, they're going to be admitted to the Union on an equal footing as the original 13 states in all respects whatsoever. And we hear a lot of theory about how the Western states just somehow did not qualify and didn't come in that way and this and that. But yet in Alaska there is a public law that says the state was admitted on an equal footing as the original states in all respects whatsoever. So it was admitted on the equal footing doctrine, and its constitution shall never conflict with the principles of the Declaration of Independence or the Constitution. So that I talk about that all the time. It's Public Law 85-508. Also a good thing to look up and read if you're living in Alaska. Another thing that Ron brings out that I would just want to point out tonight before I get into the how to bring your land patent forward part of it, is that land patent, letter patent comes under treaty law. That letter sent to the original settler on the land from the United States is a treaty. So that comes under Article 6, the second paragraph, the Supremacy Clause. I guess it's Article 6, Section Article 6, Clause 2. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land. So that treaty is made with that individual, and when you bring that treaty forward into your name, it is supreme law. What that does is it makes it so that these patents are unassailable. They can't be. They're not within the jurisdiction. All the rights, title, and interest in the land then transfers to you.
Maria?
Yes.
This is Jim.
Okay,
California.
Jim, just hold off until I stop for questions, okay?
Oh,
just
okay.
Hold off. We'll go ahead and get into all the nitty-gritty in a little bit. Okay. Here is one of the cases I was looking for. It's not exactly what I was hoping for, but it's Stone versus United States. It's an 1865 case. I don't have, the number that tells you how many times it's been overturned, but it says a patent is the highest evidence of title and is conclusive against the government and all claiming under junior patents or titles until it is set aside or annulled by some judicial tribunal. When this is Gibson versus Chateau, when there's a confrontation between two parties as the superior legal title of the patent is conclusive evidence as to ownership. Marsh versus Brooks, the patent is prima facie conclusive evidence of the title. Several others, Walton v. United States versus Beeman, B-E-A-M-A-N, or File versus Alaska. A patent, once issued, is the highest evidence of title and is a final determination of the existence of all facts. And I was just looking for one other that I thought I had highlighted. Okay, here it is. A patent issued by the United States of America so vests the title in the lands covered thereby that it is the further general rule that such patents are not open to collateral attack. That's Thomas versus Union Pacific Railroad Company. That's 1956. And then State versus Crawford in 1970, apparently in Arizona. A patent to land is the highest evidence of title and may not be collaterally attacked. That's Dredge versus Hughesite Company, 1962. These are all through Ron's book. Many cases on what the patent is and how to use it and how to defend it. And I will pause here and take a question or two, and then we'll just get into the steps on how to bring your land patent forward.
Yeah, Tom here.
Yeah, go ahead.
Yeah, are all these cases in, what's his name, Ron Gibson? Yeah, are all these cases in his book?
Uh-huh, yep.
Oh, okay, so I was going to ask the spelling. I think the first one that you mentioned was, I can't even read my own writing. Stuyvesant?
What was that again? I'm sorry.
One of the very first cases. Close versus Stuyvesant?
Yeah,
Stuyvesant?
Stuyvesant, right. Mm-hmm.
Yeah, that's pronounced Stuyvesant. I think there's a T in it. I mean, 3 T's in it.
Okay, maybe it wasn't transcribed right, but yeah, okay, that's the one. Mm-hmm.
Yeah. And then Miller versus Little. And where was the other one? And the Alaska Public Law was 85-508.
Yeah, that's the Statehood Enabling Act.
Okay.
Yep.
And then, let me see. Then you got Stone versus U.S., Gibson versus Choteau. Choteau.
Chouteau, yeah.
U. I left the first U out. Okay, Marsh versus Brooks. Walton versus, I got that wrong. I got Walton versus Walton. And U.S. But anyway, if those are in Rod Gibson's book, I'll eventually get it.
Yeah, Walton versus U.S. or United States, it says. Mm-hmm. And there's one in that, along with that one that involves Alaska. It's File versus Alaska. That was 1970. File, yeah. So that might be especially pertinent to us, 1979. Yeah. People have been saying that Alaska claims not to recognize land patents, and I did mention that in a phone call once to Ron, and he just right away just got up in arms, and he said, then you tell them they're violating federal law, Title 43, Section 83, or Section 57 and Section 83, and I looked up one of the two of those. I don't remember the numbers, but all the courts of the United States have to recognize. BLM gives you a land patent. These courts, all the courts of the United States and the courts of the several states must recognize that letter. They don't have a choice. Alaska doesn't get to say, oh, no, we don't recognize land patents. You know.
I said, well, I don't recognize you.
Yeah, how can a fiction cognize anything, let alone recognize it?
Yeah, exactly.
So, you know, we've all dealt with.
Reminds me of Tim Turner. Tim Turner said, well, I'm an attorney in fact, and you're an attorney in fiction.
That's right. That's right. Yeah, you got to be ready for these guys. You got to always be on the balls of your feet and just ready to whack back. But yeah, I guess that's why we waste our Wednesday nights this way, is so that hopefully something will come to the tip of our tongue, something we've heard. So, all right. So, any other questions just before I go through this? And I'm going to do the same thing. I'm going to go through how you bring your land forward very quickly so that, you know, we're not going to cause confusion. So that we just, what's that one, Bill? Okay. All right. We muted everybody. We muted. Okay, everybody else is still unmuted. You are making a little noise, Tom. But I'm going to go through it fairly quickly so that you kind of get a clean, a crisp understanding of the full picture. And then after I've gone through the process, then you can ask your particular question. Now, this is in Ron's book on 2 pages, 114 and 115. And so if you're following along in your book, but it's on two opposing pages, 114 and 115. And he also goes through it in his seminar, and I noticed it's really, really close to what the coaching that we had from various people, some in Texas and some in New Hampshire at the time. But even there's a little bit of a disparity between the seminar and what's in the book and what I'm going to do. So I will let you know where we diverge a little bit. And it starts right at the beginning. In the book on page 114, at the top it says, get a copy of your metes and bounds description. And where your land is located within the section. And you're supposed to get this from your own file on your purchase or from the title company. But in Alaska, what we understood is that Alaska doesn't use metes and bounds descriptions. And they hadn't ever used metes and bounds descriptions, supposedly. So this is going to be one of my most important questions for Ron. We were not able to get a metes and bounds description on our land. So where we started was we went to the BLM and got the letter patent from BLM on that particular property. And we were able to do that with what it seemed like no problem, and it sure looked like it was just the same. It had to be the same letter patent. So we were able to get our patent just by using the lot and block description. But he does say in his book, do not use the subdivision or the tax ID number for this identification purpose. So when you go to BLM, you don't want to be using the subdivision or tax ID number. But the takeaway message here for step number 1 is get 3 certified copies of the letters patent from BLM. Conveying the land from the United States Trust Compact into the private hands. So 3 certified copies of the letter patent. Preferably by telling them your metes and bounds description. Okay, so that's step 1. Step number 2 is get 3 certified copies of your chain of title, the history of your chain of title. Have those certified as well through either the recorder's office or by hiring a title company to do the title search for you. But you want each link in the chain of title to be certified. Step number 3 I have here, find the metes and bounds description. Do all that you can to get that metes and bounds description. In fact, some people may even go to the extent of having the land surveyed. And I honestly can't tell you all the ins and outs of what that would mean, but there were people at Ron's seminar saying, should we have our parcel surveyed? And he thought that might be extra good insurance. he also mentioned that you can get the meets and bounds description by going to the county recorder's office. Now, we don't have that, so you'd have to go to the recording district in Alaska and do the research there. And I guess all of that information really is available online. But you want to have, to the degree that you can, get everything certified. Step 4 is to get 3 certified copies of your statutory warranty deed or whatever color of title that lists your legal name as grantee of the land. So your legal name on a statutory warranty deed, or what you have showing that it's yours. Step number 5 is write a declaration land patent in which you declare all facts pertinent to your ownership in this parcel of land that's in evidence on the warranty deed, the chain of title, and meets and bounds description, which is part of the original land patent conveyance. And within this declaration land patent, make sure you ask anyone with a claim, any claim to this land, to come forward. And the way that we worded it is so that all undisputed claims may be settled forthwith, and that any disputed claims might be settled in an open court of record, trial by jury. We also said when that open court of record, trial by jury would be held. That's a common law court of record. Has all the characteristics of a common law court of record. So that's what we were saying is, if you think you have a claim, you're going to have to deal with us man to man. The other thing, make sure you let people know, speak now or forever hold your peace, and then sign that declaration, autograph that declaration in your lawful name, and have 2 or 3 witnesses attest that they saw you autograph this declaration. And basically what you're saying, and there is an example here in Ron's book of how he does his notice of certificate of acceptance of declaration of land patent. His is a little bit more wordy, but there is definitely a prototype that you can use that's in his book. But it basically is what you're doing is saying, on this date, I gave $20 silver coin, or 20 silver pieces to the man who you bought it from, and so that resulted in a legal name on a statutory warranty deed, and then you can go either direction from the time you bought it backwards, or you can go from the time it was conveyed to the original owner forwards, but you just want to go in a logical order and make a declaration of land patent. And so that's one of that kind of wording is one of the most, important parts of how you do this, and so that's going to be something that we're going to have to do at another time, and just really get into how you write that declaration. But so that's step 5, and you would include those certified copies of everything that you've gotten as exhibits to your declaration as proof that what you're saying is backed up by these lawful legal documents. Okay. You've got your 2 to 3 witnesses attesting that you've autographed the declaration, and then at that point you make copies of all the pages. And what you would do, the reason you need the 3 certified copies of everything is so that you can have 3 full sets of originals, just in case anything happens. So you wouldn't have to go back and, if something happened, you wouldn't have to go back and request them over again. As long as you're requesting one, you might as well get 3. So you'd make copies of one of these 3 sets that you have that have the certification on them. You just make a photocopy of one of those full sets of the originals. You'd keep the originals. You do not post the originals on a public notice board. You keep those originals safeguarded. So you have 3 safeguarded originals with certifications. Then you have another set, or say maybe you even have 2 more sets. And you find a public notice board, and you post that copy for 61 days. Okay, 60 days plus an extra day for any partial day that there might be. You also need a declaration. He recommends doing this declaration that says you have a witness or 2 witnesses that saw you posted on such and such a day, and then you take that same witness or 2 witnesses back that say you went back after 61 days and they saw you take it down. So that's just also extra insurance. Probably nobody will challenge you that you indeed posted it for 60 days. You could also do, stand in front of the bulletin board with a newspaper from that day and make sure the date on the newspaper is visible in your photograph, showing that you put it up on such and such a day. Then when you come back, you could probably get a newspaper from that day and show that you're taking it down on that day where the date is in evidence on the newspaper that's in your photograph, something like that. That's, again, extra insurance. And then once you've let it cure for 61 days, depending on if anybody has brought forward a claim to the land or not, then you write what happened. No one came forward with any claims, or somebody came forward with an undisputed claim and it was settled, or we've got a disputed claim and now it has to go into the public, or we worked it out in private. It was a dispute and this is how we worked it out. So any of the claims that are brought forward, you testify to those on paper. You make another declaration. And then you have all of this recorded. You put it together in I've heard some people call it a sandwich. You have this, I think some people were asking if it needed to be registered or something, but just record it at the recording office. And record your declaration, land patent, and that it's cured, and then just safeguard all the originals in a safe that's fireproof. And that's basically the process. So, of course, there are some ins and outs and some detail in that, how to write that declaration, and some other ins and outs in the process, but that's basically it. So now I'll pause again and see if you've got some clarifying questions. It's basically an administrative process. It's, nothing earth-shattering. It's just that whether or not you want this land to be on, under land law or under commercial law, and whether or not you want to be able to assert that you're one of the settlers of the land and that you created the government. I think it's incredibly good prima facie evidence that you're one of the people. Any comments? Anybody want to attack any of that or comment, or please go ahead now.
I got a quick question. Dave Bartels.
Hi, Dave.
So, hi. So you're saying that's evidence of being one of we the people?
Yeah. Mhm.
Okay, so are you also saying that a citizen of the United States couldn't get a land patent?
I don't know the answer to that question, but I do know that Ron has that, basically takes that stance. That even in his book it says over and over again, and I've actually asked people to ignore this, but it says that only a sovereign citizen can do this.
Because I know when you read the case law and the Civil Rights Acts, that's what they were doing for the Negroes when they made them citizens of the United States. They'd have can't remember the exact language, but the right to acquire and possess whatever, hold, property, can't be deprived of it without due process law and stuff. So I would think that somehow they made provisions for them to be able to, see, that's the tricky thing in the language. You can't tell if you're getting it all. It should tell you right up front where like if you were buying land and you thought you were buying the whole thing, like say as the absolute owner, and then if you're not, it should say that Joe Blow has the equitable title or whatever, and you have the legal title. So, because that's what I understand. It's droit, just duplicate them. The double right in order to hold it. And I know the people originally here owned, after they took it by conquest, owned all the property. But I don't know that when the people, it would seem like settlers that came over from Europe that weren't considered we the people, they could have been free persons or a citizen of a state, they would have had property. I think most of them thought it'd be really weird to come over here then and not be able to own property, but I don't know exactly what they did.
Yeah, no, and that's definitely part of the history that he goes through, is that was one of the most important things to the people that were coming. And we know that some people came just because of the Homestead Act and just because there was free land. But here's I basically disagree with. I would never argue this. I would never, if somebody identified as a U.S. citizen, I would never bring up the argument that you have to, if I were they, I would never bring up the argument that, of course, I have to be a sovereign American citizen free of all legal disabilities to hold title to any land in the United States of America, which is what Ron's book says. Why would you ever bring that up? Make your opposition bring that up. Force them to bring up accuse you of that. I don't think anybody would.
I'm not sure right now, but I wanted to say that when they do foreclosures to take your property, it's all off in equity. You don't get a trial by jury. I don't know all the ins and outs, like for an example of, I don't care, I'm demanding it, because that's how, you shouldn't be able to be deprived of anything unless you're the non-sovereign and you committed a crime, so presentment and indictment by a grand jury, and then you're convicted, and their statutory law provided for it. Just like if you look at our Constitution, where even on conviction they can't do a forfeiture of a state.
Mm-hmm.
The whole thing goes way back to England. Man's home is his castle. But yet they do all these foreclosures in equity, and they require your consent. See what I'm saying? But they don't tell anybody. And they don't want to fess up to it.
Well, and that's a big motivation for, it's allodial versus equitable title. I mean, that's the whole point, is that you want to own it in allodial.
Well, that's what I understand when the patent starts off. that because with a little bit of, I did quite a bit of research, but not extensive, where I feel like I'm an authority. I know quite a bit on it, but I'm not going to sit and bet my life until I need to do more research till I feel I got the whole thing down. But once the government conveys it, they're done. It's just like, cut the string. We're done. It's yours. It's ours. We can't take it back.
Yeah.
Unless there was a fraudulent conveyance or something like that.
But they have to have evidence. They have to have evidence, and they have to.
Nobody has a superior. Like if you have fee simple, why they went to fee simple is that just because get away from the word allodial? Like that's still in Minnesota's constitution. All land is allodial. And
yeah,
it should
fee
be
simple.
Everywhere.
Fee simple is a fife or a fee, just like the king. There's still a king overlord over you, which is the international bankers. I mean, that's how it's worked.
I didn't see that. I checked on that because there was fee simple absolute, and they were synonymous, and nobody had a superior title over you. That's what I remember.
Well, okay, so we're talking about, and that could be true in American law, but it's the derivation of the word.
Oh yeah.
Fee simple absolute.
Why did they go to that crap instead of leaving it allodial, and it's a part of the allodial patent, language a little bit more like that or something, instead of all this Babylonian garbage to get where they're going is what's going on. That's how it seems to me.
Some of this, yes, and you're right. Some of this is just when it seems to me that this is how we lost our land jurisdiction, by not bringing our land forward in allodial. I mean, we lost it piece by piece. And then all of the counties left the land jurisdiction and went into commercial. They're all commercial governments. They're all corporations, right?
Mm-hmm.
Would they have been able to do that if there were landowners that brought their conveyances forward? I don't know. Would they have been able to do that if people didn't all become citizens of the United States and accept benefits? I don't know. But I have a feeling that we lost it for ourselves.
Well,
they did.
Here's what I believe it is. I believe it's just a pretended fraud by these servants. They're trying to do it, and it's such a fraud, so they dream up all this complicated crap. And in truth, you own it, because you were never given disclosure that you didn't, to your assent, because that's meeting of the minds. There's nothing right there that's undeniable. Everybody looks at, well, how could you not know you didn't know it? Look at that right there, it says. Anyways, and they're supposed to be securing our rights, not conniving at our defeat.
Yeah.
And I know the borough thing, I think last time I just said briefly in their, I don't know if it's the tax bill, I think, but anyways, I was saying in quotes, they have, they're on their little, you get the little cards up there too, like postcards with the tax stuff on it?
Yeah, I think so. We haven't gotten one for a long, long time, but yeah, I think so.
Okay, so you don't have to pay taxes up there yourself?
Where we are now on Deltana, there are no property taxes.
There's no incorporation there?
No, but
anyway,
up
if you
up
look
in
at those, they're...
But I mean, listen to what you just said. There's no incorporated borough here. Yeah. It's an incorporated borough making an offer to contract with a man who's also got a royalty in corporate. Yeah, it's an offer to contract, and you've got to say, no, I ain't doing it. And I brought my land patent forward. I'm the tippy top owner. I have all rights, title, and interest, and you have no justification whatsoever to presume upon me that you could make me an offer to pay you this tax. It's just, let's get the relationship right. We've got to get
they
our
won't
relationship
admit it, though.
right.
I did all that when I tacked the borough on it.
Mm-hmm.
I denied anybody had any superior right, title, interest, or dominion in my property. And who is it if you have it? And then they're using the word coupon. I quoted it right with what they're doing. That's contract. Where's the contract? Let's see it. I deny there's a lawful contract, with the meeting of the minds. And they just go silent. They go sideways.
Yeah. Yeah. And then they still want to, what do they do to enforce it?
They just go ahead and transfer it. What are you going to do about it? They just do a clerk's deed and transfer it instead of due process of law. When they do the execution, they don't do it by writ or warrant. They just do it. It's by court rule. Then they don't show how they're entitled. Just a fraud scam to the nth degree.
They won't show anything. Yeah. So
nope, they won't admit anything. They won't show anything.
So then they sell it? Do they sell it?
If you don't pay the taxes on it, they do. Yep, they put it up for auction.
And then what if you've got a claim? What if you have a claim and you bring your
If you want to try to go against that person that bought it, I think they even put in it, because I never let mine go, but a friend of mine did. He let a $600,000 place go in Anchorage, totally paid for. Trying to fight this, and he's still fighting. It's been probably 5 years, and he's get all these guys on the commercial law and everything, and spends all kinds of money on them.
Has he brought his land patent forward?
Oh, I doubt it. I don't know for sure, but I doubt it. It was in Anchorage.
Okay, so the whole thing is identified as commercial, and the tax deeds, the tax bills must be enforceable against a commercial property, against a property that's in that jurisdiction. I think you've got to. I think you have to remove it to the land jurisdiction. I mean, that's what Ron's going on. We've moved it.
Is he not having to pay taxes either?
He shows you how to take the parcel off the tax roll.
So and he's got his off the tax roll.
Yep.
Okay, so if he's successful, then that's the avenue to try. Then I'd recommend he probably puts it out there, the proof of it.
Yep. That's what this is. This is what he's been doing, and this is what watch his seminar. And in the book, he says, "I've done it. I know this is true because I've done it." And he takes them to treaty law. He takes the courts to treaty law. He uses Title 43 treaty law and 432 in the Constitution, the needful rules. And so he's got all the basis for what he needs. But you've got to accept the conveyance that is the treaty, that is the land patent that the United States conveyed when they divested the trust of the land the first time, and in this book, I mean, he has got, and it's step-by-step instructions. We're going to have to get clarification for how we do this in Alaska with the meets and bounds problem, because what we have understood is that there's no meets and bounds description.
Well, they were on my land patent, I know. The original one, it encompassed the whole homestead. And you can get that down at the recording office, You just backtrack it to the patent on the subdivision. But then I don't know how you do it after that.
Yeah.
And I see somebody knows, I believe, because I didn't know anything about it or anything about law during the crunch in the 80s, and I worked for Totem Real Estate in Anchorage, but they had a sub shop out in Wasilla, and I noticed that they had a duplicate map. One was of meets and bounds, and one was lots and blocks. I just remembered it because it's like, wow, how come they're using lot and blocks? They got all this. Well, why aren't they using both or whatever?
Yeah, and I wasn't our meets and bounds. The meets and bounds was on the original patent, but yeah. Huh.
And what I remember about deed is just possession. And the other thing I got just for a tidbit of information, titles are a fraud to begin with, or they can be used for a fraud. When you really have your property, think if you didn't have any titles someplace in this country at some time, then somebody's trying to say, oh, you don't own it, you don't have a title. and then you get a title, and next thing you know, so the government owns it. You know what I mean? You get me?
Yeah.
They're good as long as they're not fraud. Just more evidence that you own it. But that's usually how it is. You just like you buy something, you pay cash for it, and it's yours. If it doesn't have a title, and what do you mean it's yours? It's in possession's 9/10 of the law. It's kind of 100% unless somebody did a fraud. Like you stole it from them or just pretending you bought it. Anyway, it's really disgusting because no one should ever have to lose their castle.
That's right.
And Webster said that he felt that fees on property were more dangerous than standing armies. Because Otis declared there's several court cases on this during the Revolution. About the man's home is his castle. Have you read his saying where, I forget how it goes, but like a shanty in the rain, wind may blow through it, and the rain may enter, but all the forces of the crown dare not enter.
Yep.
Look what they do here.
Well, what we were saying about title, back to that, the title is they're saying that these letters patent are not the title. It's just prima facie evidence of the true title, or as it used to be called, the absolute title is what they used to talk about in common law. The title is in the acts of Congress. The title is in the law. It's not the letter patent. The letter patent is just evidence.
Okay.
And so when you get that letter patent from the BLM, you'll see the meets and bounds description. You'll see a description, but that's the entire parcel, like you said, the entire conveyance. So it could be, entire section or 40 acres, and then maybe your piece is just part of that. So that's the thing, is you just have to claim, and on your declaration you make it clear that you're not claiming that entire parcel is yours, that entire conveyance. You're just accepting the part that's yours, evidenced by the warranty deed. You're using that warranty deed as some evidence, although the description on that is lot and block, because it's commercial. So this is a big question. This is a big confusion for me. You don't want to use a commercial description to identify a land jurisdiction piece of land. You want to use the meets and bounds description. And so how do we do that? How do we get that?
Yeah, we should be doing some calling, even like whatever the appropriate offices are, to get where we're going. They're not supposed to be conniving against us. But anyways, get it recorded and or videoed so we got evidence to show people this bullshit where they're ruling us in reverse. It's maddening.
Yeah. That's
Tom here.
See all the time. Go ahead, Tom.
Yeah, a couple things. I missed how to get a hold of where Ron Gibson's seminars. I got Liberty was the only word I got out of that. And then I have a comment on the meets and bounds.
Northwest Liberty News. It's a guy on YouTube. I'm sorry, I can't pull up his name right now, but yeah, Northwest Liberty News.
Northwest Liberty News, that'll get it for me. And then the piece of property that my ex and I had in North Carolina, the survey was, really old-timey stuff, like, from the iron pipe set at such and such latitude and longitude, then southwest to the Spanish oak tree, then along the fence line to an iron pipe set at such and such, and it was. So I'm thinking if you have a piece of the original land patent, you just hire a surveyor to come out and do it, and then there's your meets and bounds.
Yeah, and it's just Anglo-Saxon English. You can hear it in that meets and bounds description, and I wonder, can you do your own?
Well, I'm thinking that the surveyor could.
You got to be survey accurate because
you don't want to be accused of taking somebody else's property.
Yeah.
Yeah, on my mom's piece of land, there was an error in the recording of the thing at the county, and because they've got a computer and they've put all these figures into the computer, and the computer says, well, these two pieces of land overlap and these two pieces of land have a gap in between them. Then they'll go and correct it. And then you have to go with the county's correction after that because of the errors in the surveying and whatnot. So that's just a little bit of, I don't know if I'm correct that the surveyor's write-up of the land would be the meets and bounds, because it's written out. It's not just a map with, marks on it. It's actually the description in writing from this point to this point to this point and so on. So, I think
that is how it's derived, is that you start with one point and you go so far in such and such direction until you hit another point, and then you can describe that point. There's the stream, and then you go, again so far in such and such a direction. So that is how you derive a meets and bounds. And so if you had the land surveyed and you specified that it must be a meets and bounds description, the surveyor should know how to come up with one of those, I would think.
Yeah, I would think. But
mm-hmm.
Okay.
But yeah, no.
So I don't have a piece of land. But I'm thinking that it's going to get close to the time that I'm going to get one. So maybe I'll just to simplify things, I'll just go to the unorganized borough to begin with. But yeah.
That's a thought.
But anyway, then I can work on it for a while.
Well, and if enough people in Matsu brought their land patents forward, it would soon be an unorganized borough.
Well, that sounds good. Unorganize the borough, like a sign John has up in his house, his borough, and ass that rides the taxpayers.
I mean, this is, to me, if a few years ago, 10 years ago, when we started all this political mumbo jumbo, if only we had known that this would be our work, this would have been a great way to spend our time. And we'll see how much longer we have. Maybe this will be the thing to do to really to retake the country.
We need some lawful courts. That would help.
Yeah, and to me, this is still, how do you get those lawful courts? Well, people say you assemble. But I think the assembly needs to be landowners.
Well, this is going back a while, but 20, 25, 30 years ago, a man discovered that all of the de jure offices were vacant. So he assembled a group of landowners in Colorado and had himself elected governor. And then the military found out about it and assigned this Marine with a JD degree to go check it out and see if this guy's process was legitimate, because they were looking for a way to not have to fight World War III for the corporation. So if that story's true, I remember the guy that was the de jure governor of Colorado had a website up for a while, but then it disappeared. But anyway, it used to be that if you didn't own land, you didn't vote. So, I think if you receive government benefits, other than, I get Social Security, I don't claim that. I don't consider that a government benefit. That's just money they defrauded me out of that I'm getting back. Because,
are they deriving their just powers from the consent of the governed, or are they, are we self-governing or aren't we? Are we sovereign? If you're sovereign and you form your own community, your own government, your own state, you're sovereign. You say, okay, well, I'm going to freely associate with this group now. You know, and yeah, we all happen to own land in the unorganized borough, and we're going to associate, and we're going to have, you know, when we have a dispute, people will have to draw from our jury pool, from a pool of our peers. Here's our peers. We've come together and we've assembled into what it is that it means to us to be self-governing. It's simple. You know, it really needs to be simple. But we've got to show that we understand what being a land jurisdiction statesman is. Being a landsman is. It means that we only operate, you know, with one superior. You know, we've got a creator, we know who he is, and that's how we're going to live our lives. I mean, that to me was the whole beginning of why the Reformation Christians left Europe and came to this land.
Well, I think that patent's a good idea, but it's getting at the bottom of how they're taxing and exposing it's by fraud to begin with. Every indication I can see, they're just pretending they're providing services and contracting with you. Remember the coupon on the tax bill, in quotes, in all caps.
Yeah, but it's all presumption you want to be part of them. It's all presumed on the idea that you want to be part of it, because
they're saying right out there that they're contracting with you by doing coupons.
Oh, okay.
Then they don't want to honor it.
Mm-hmm.
They don't want to go there. They don't want to. But why would they have it? When you read their statement, it's all proper English grammar, and as I remember, it goes to quotation mark, and then all caps, and I think it's even red instead of just black, and then quotation mark, it says coupon in it. This coupon. Like, other than that, why would they be doing it? And then you look up what coupon is. I got told that by somebody else that was doing this stuff.
Let me go back to when you said they'll take it anyway, okay? Mm-hmm. Here it is on page 31 in Ron's book. All right, there's a hidden federal lien on all real estate in the federal United States because of the federal debt to the International Monetary Fund. This federal lien is not attached to the land, but to the property and real estate, so the appurtenances, the house and the buildings. Okay? It is assessed and collected through the property tax. And so this is what he says. Discover how much federal debt is attached to your property and real estate by writing to the Department of the Interior, requesting an accounting, and tell them you want to pay off the debt. And you can either borrow money, FRNs, and pay off the debt, or offer them to pay the debt in full in gold and silver, and they'll dishonor your payment, and that will result, of course, in a dishonored payment of your form of payment will result in a credit in that amount. Now you can sue the title insurance company for triple damages for not revealing the hidden federal lien. Okay, so then you sue them. Then once the lien is satisfied, you take it off. You tell the tax assessor that the lien's been satisfied. That's his theory on how you go through and get that parcel taken off. But if it's still listed as a parcel that's got a federal lien on it, they're going to take it. Would be my guess as to what he's saying. I believe that's what he's trying to tell us.
Yeah, Tom here.
Mhm.
Yeah, well, here's a couple of problems with all of that. And I'm saying it's problems for the so-called creditors. You have this fiat money Ponzi debt scheme that qualifies as odious debt. And I think it's going to be repudiated here pretty shortly. So I think that'll go away. I mean, when you look at what was done with the creation of the Federal Reserve, and this is why I would support a constitutional amendment requires the Congress to have quorums present in each house to conduct business, because they had 3 members of Congress and the president that put in the Federal Reserve, and everybody else was just not even consulted on it. So basically, the Constitution does not provide for Congress to delegate away its money creation authority. That's it's totally bogus from the get-go. So these bankruptcies proceeded, to be settled and reorganized and on and on and on, going back a long time. And when did the IMF come into being? It was after World War II, right? Am I still?
Yeah,
am I still on?
Yeah. I don't know the answer to that. Yeah.
Yeah. So, it's fraud upon fraud upon fraud. So, maxim of commerce, fraud vitiates the most solemn oath to pay. So, I think on a big scale here, we're going to see the repudiation of, all of that debt, and a big fat debt jubilee. I think, maybe not, but I see signs of it around the edges. Anyway,
we
I
need
yield.
a total jubilee.
What jubilee?
A total jubilee.
Yeah. Well, anyway, I yield.
Yeah, you're right. I mean, this hidden federal lien is all a result of fraud, and
you know where the patents come from? The federal patent, what clause it comes from?
What clause? Yeah.
That gives Congress the power.
Well, there's several clauses. There's the property clause. Yeah, the Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory and other property belonging to the United States. It's 432, Article 4, Section 3, Clause 2.
Because I have the Supreme Court of the United States saying it comes from the, where they do patents for inventions. I was like, you got to be kidding me.
Yeah, no.
No, that's what they're saying. I can show it to you.
Yeah, but it's not right. It's not accurate.
Then they don't even know, huh?
No, they're expressing their opinion.
and then we're the ones that own it to begin with. I have all that. When they say the property of the United States, that's owned by the people. It's just held in trust.
Yeah, absolutely, yeah. It was just given over for specific purposes, and then they did try to twist the purpose around and hold it in.
Have you read USB Alaska?
No,
I think it's that one, or it's either the one that was the judge up here, one of the two. But that was, anyways, in USB Alaska, they were just saying it was effectively a quitclaim. And then when they were doing the transfers, all the private property just stayed. They were just transferring government-owned stuff. And they didn't have the capital. Remember, it was at first in Sitka until they could buy property.
Well, but this is wallpaper. This is wallpapering over the truth, because originally, when the trust compacts were formed, it covered all the land that would later be acquired. It doesn't matter. They said that all the land that will now, that our western wastelands we're putting into the trust, but also any more land that's ever acquired by the United States has to go into this trust compact for the benefit of all the states and all, it doesn't say all the people, but for the combined benefit of all the states, and all the states are going to be admitted on an equal footing. They're all going to be just like the original states. So if that's not asserted, it's like, how dumb are you? They're looking for us to be ignorant and for us to accept this BS they're handing down. It's just total bull. We go back to the original trust compacts. We go to, there's a really great veto. President Jackson vetoed in 1833, said it was an attempt by Congress. He vetoed the Land Bill of 1833. It was an attempt by Congress to alter the purpose for which the funds derived from territorial and public land sales. I mean, they were trying to take it in 1833. So, yeah. No, that's a no-go. They can't do that. They can't rewrite history. So.
Well, they've been able to overthrow every government in this country twice, so they're pretty good at what they do. I'll give them that. It's evil.
Yeah, we've got to be better at we've got to be better at being self-governing, right? I mean.
Oh, yeah, imprudent to the nth degree for the vast, vast majority. I don't know if you've noticed it, but I've noticed that there are many people out there that they are so under delusion and sick that you can put the truth right at them, and you can barely even get any kind of rational response. Like, can you prove that, or show me, or that's not true because of this or that? They just kind of go deer in the headlights, like you're talking moon language to them or something. And I'm pretty good at it. I mean, I'm getting better as far as realizing that you can't just say law language and get where you're going when you're dealing with these people. But I'm just saying, it's, they're like lawless is what I see. They're so lawless, and as far as they're concerned, the law, they don't care as long as it's what they want or something. You know what I mean? It's scary when people are that sick. They're not that sick in other areas.
They seem to want to know if you're one of the compliant ones or one of the non-compliant ones, and that's all they care about. And, this is one of the non-compliant ones.
I got a comment, Tom.
Go ahead, Tom.
Yeah, I remember trying to wake up my ex-brother-in-law years ago, and I was talking about the fraud of the fiat money system and so on. Well, his response was, well, that's way above my pay grade. It's like, oh, my gosh.
I know.
You want to punch them, or they look at you like you got three heads or something. But now, it's funny, these millennials, some of them are pretty woke. And I used to go in this local watering hole where some of the military from the base hang out here. And I got talking to a couple of gals, and they were talking about all kinds of crazy stuff that, I wouldn't even venture to tell people, that. And I said, well, how many people of your age group are as well informed as you two are? And one of them said about 10%, and the other one said about half. So I think, if you can find the millennials that have sort of got their head screwed on straight, those are tuned in. So I think I'd just like to know where to mingle around and meet some of them. Because, some of them are probably, and one I said to her, I think she was about 35 at the time, and I said, did you know the United States is a corporation? She said, oh, yeah. I said, where'd you learn that? She said, in the Air Force.
Huh. Wow.
Yeah. So I think the enlisted ranks of the military are a pretty good place to go. If you meet any of them. So that's just a word of encouragement to the younger people. If you can find the ones that aren't just all wigged out, they're the ones that are together are really together, and they'll listen to you. Anyway, I yield.
Yeah, we just have to work with who there is out there, and just, I don't know, just keep working on it. I think I don't think it's, it's just a small percentage of the people that lead, and everybody will have a different take on what the right thing is to do. So just keep the faith, keep the faith and keep going forward. But I think I just believe that this is one strong stance to take. Bring your land patent forward. Help people who do have land bring their land patents forward. Doesn't have to be yours. It almost doesn't matter.
I think the biggest problem we have is the court system. Because if you can't get judges that are honest to be trying to secure your rights like what's supposed to be going on, so what do you mean I don't own the property? And somebody comes up with some Babylonian excuse why you don't. Like, this ain't happening. Where's the full disclosure of that? There's no meeting of the minds.
Well, and
ridiculous. All these loopholes, all these hoops, you got to jump through to get where you're going. It's preposterous.
It absolutely is, but we have to have kind of a restoration of our faith. We have to be faithful and, know that this is the right thing, and it is right, and it is based on our law. And let's uphold our law, because if you have more faithful people, the courts and the judges can't continue to do what they do. The more
they can, because they're unaccountable.
Well, we've had a regardless, you still have to do the right thing. So I would say it's an administrative process. I'm just talking about the, the land, bringing your land patent forward. It's a simple administrative process that everyone can do. It's fairly simple. It's the right thing to do anyway. And the more people that are pushing it, the more, and I think Tom's right too. I think we're going to see, I'm afraid we're going to see a huge reset, throughout this whole this chaos magic we're in right now. But you got to do the right thing, and we've got to. When you start to get a hold of this information and you see how simple it is, and you see what it's based on, and you read the law, it's refreshing. It's truth, right? And so, I don't know. I think it's a good thing to share and to deal with. There's a lot.
I think it's a good thing to try, that's for sure, because you want to be the owner of your property and where nobody can take it from you without due process of law.
Yep.
But when they're all in on it, how do you defeat it? That's the thing. Got to get that exposed.
Yeah.
I put a lot of times to abolish the court system and I actually say abolish the super corrupt court system and open up the judiciary.
Mhm.
Just to put it out there. Put it out there for a while, and maybe people then what? And they want to know step 2. Like what's up with that?
Mhm. Yeah.
I even do it on State of Alaska, and I cite where it's at in the statutes and open up the State of Alaska.
Mhm. Yeah.
And I think a big complaint to be putting out there, how is it we have all these government servants, emphasis on servants, and they're all in on the scam of not securing your rights and committing crimes and fraud and injustice on us? It's like if anybody had a brain, if you couldn't bear arms then for security of free state, I don't know when you can. I'm not saying an advocate, but it's just like the act of insanity just because, I don't want to lose my job. Sorry, we got to take your land. Sorry, we got to kill you. Sorry, we got to jail you. but we're just doing our job, and I don't want to lose my job. It's like it's a frickin' madhouse. I've never seen anything as nuts. When you get to those pinnacles of truth that they don't want to go to, other than that, they can act like they're the greatest people in the world. But the judges go blah blah blah, and what else you want to know? Blah blah. You know, where's the Alaska court system created? And then the fangs come out. We ain't going there. You know. Anyways, that's for me. I get frustrated because I help a lot of people, and sometimes it goes good and it feels good. It's like, relief, not another just nightmare. And then, you know, where they dismiss the cases, and then other ones, it's just like you could lose money on because you felt it would be so easy to get this one dropped compared to this other one, and then they drag on and drag, you know, is it because they're different judges? You know, different prosecutor? I don't know. You can't tell. They won't tell you. They just keep their agony on. Fortunately, it's not me, but I take it kind of personal for these poor people going through this stuff. You know what I mean? I could just get indifferent. Whatever, it ain't me, buddy. Maybe you ought to have been done a lot more about this a long time ago. But I take it personal because I know they're suffering.
Yeah.
Stress.
Yeah, I'm sure.
And it's all crime.
And it's really horrifying when it's kids that are being separated from their parents and you're trying to help and they just act like it's a mundane something they do before lunch, something they do, you know, between their breaks, and it's not important to them, and who cares? And you know, it's just
I've never seen people that sick in the court system, whether it's the judges or the DAs, and I'm not saying every one of them, because we've had, I was working on this one case, and this so-called best attorney in Anchorage said, he says, there's nothing more I can do for you. It was this guy I was helping. We're going to have to go to trial. It's going to cost you a bunch of money. We got the recording, and he says it 3 times, and we finally got it dismissed. Took way too long, but we finally got it dismissed, and the new DA came in one day and says, Your Honor, we don't really have much of a case. No kidding. But yet, you know, you can't force them, grab them by the neck, and either prove up or dismiss. You know what I mean? It's maddening.
One of the guys here wanted to go in and talk to one of the mayors, and he called and he said, hey, can we come by and educate you a little bit about the law? And the guy said, no, I don't want to be educated. Yeah. The mayor doesn't want to know the law, and the troopers said, don't give me your rhetoric. You present the law, and they want to tell you it's rhetoric. So it's extremely frustrating. They just one of the mayor's assistants told a guy, you have to sue me in order to get someone acting lawfully in government. They believe you have to go in and file a lawsuit against them. You're going to have to sue your servants to get them to act in a lawful manner. So, if it's okay, I want to go on to the second distinct topic that we had for tonight, and it does relate. It's Public Law 102.14, implementing Noahide laws. These are supposedly the 7 laws given to Noah. They're being touted as the bedrock of civilization. They were brought into the United States. Let's see. Adopted, passed by unanimous consent in the House of Representatives during the Bush administration, 3rd of January 1991. Some House representative came up with this bill supposedly for the purpose of celebrating the birthday on 26th of March of Menachem Mendel Schneerson.
Further, I'll refer to him as MMS because, but anyway, his last name, Rabbi Schneerson. He's the guy who worldwide wanted to bring the Noahide laws all over the world. And so there were 225 co-sponsors to this bill. And it was 225 congressmen that thought that this purpose of this public law, this House Joint Resolution 104, was for the purpose of celebrating the 89th birthday of Schneerson. And so they sent everybody home. There was actually a congressman by the name of Bill Dunnemeyer, who was a congressman from 1979 to 1992, who said he was in the House of Representatives. He was in the chambers voting on a bill that day and had no knowledge that this bill would be voted on. They sent everybody home, said the day's business was over. And just like you were talking about earlier, it was 4 congressmen in a voice vote. No votes were recorded, but 4 congressmen in a voice vote passed this by unanimous consent, celebrating every single year. 6 presidents, including Trump, celebrate Education Day. And it's actually the celebration of the birthday of Menachem Mendel Schneerson and the implementation in this country of the 7 laws, the Noahide laws. Okay? It was actually even, they're calling it the bedrock of society. The historical, ethical values are all based on this, and so that's why they're tying it into Education Day. And what they're touting this as, and what happened when Trump celebrated this education, he celebrated Education and Sharing Day and talked about the revival of biblical education. But it is not the revival of this biblical education. So why should you care? A few reasons, and that is that the Noahide law is going to form the foundation of something called the ICS, International Court of the Sanhedrin. These are 7 laws of the Talmud. And they seem innocent, but it relates to an extreme right-wing Israeli group called Otzma Yehidu, and I don't know if I've even written that down correctly, but Otzma Yehidu. And you'll hear it also, this particular group called Shabbat Lubavitch. I can't say it. Lubavitch. Okay? The Talmudic laws seem innocent and even consistent with the 10 Commandments. There's no stealing, no shedding of innocent blood, no idolatry, no sexual immorality, no cursing God. But they also talk about no eating of flesh from living animals and establishment of courts of justice. But the power of interpretation is with Shabbat, which it's the Sanhedrin. So it's a huge group of rabbi judges, and they have the power to interpret this law and decide who's breaking the law and who's guilty of the law. The sin of idolatry comes with capital punishment. So decapitation. You could lose your head. And this law applies to Gentiles. it doesn't apply to Jews. So if you've got to realize that the perspective and those interpreting would say that anybody who's a believer in Jesus Christ is guilty of idolatry. Jared Kushner, the son-in-law of Trump, is a Chabad Lubavitch. That's the right pronunciation. Chabad Lubavitch member. The Sanhedrin has called on Trump to promote the Noahide laws. President Trump declared Education and Sharing Day, celebrating Rabbi Schneerson's birthday, issuing a declaration inviting a delegation of Shabbatist Jews. This was started by President Carter in 1978. And then Bill Dunnemeyer writes this letter that says, look, this has been on the books since 5th of March 1991, the House passed it. 7th of March 1991, the Senate passed it without any knowledge or input by the people of the United States. And according to his letter, by even members of the House of Representatives and probably members of the Senate. And he thought the people who were joined on as co-sponsors just thought it was a birthday celebration resolution. Anyway, there's more there, but wanted to bring that out and just kind of point you guys. I sent it out in an email. I sent out the source of the information where I got that from, and that was Stephen and Yana Benoon, who have a channel on YouTube called Israeli News Live. Israeli News Live, and they're talking about it. You can look. They're interviewing Chuck Baldwin in different places. They're interviewing. They have quite a few interviews, but mostly they're bringing actual documents to your attention. So I wanted you to be aware of this Noahide laws being implemented, and just very simply, it is legal to I thought I wrote that down here. Let me read this.
So
right now, it's legal to accuse, to convict a Christian in the United States. It's legal to convict a Christian of idolatry and give him the death sentence based on this adoption of the Noahide laws.
So
go ahead.
If you're idling Christ, then they can put you to death.
Yeah, if you believe in Jesus Christ as your Lord and Savior, you're a Christian, you're a confessing Christian. Here it is. Your U.S. government can now legally kill Christians for the crime of worshiping Jesus Christ.
Well, that Noahide thing, it's been around quite a while, but we've actually got the proof now that they haven't enacted any laws since the revised statute. We've got certified copies from archives, just like they're not using the proper enacting clause, but it's even being talked about in Congress that they haven't enacted any of them.
Mm-hmm.
And they're all the servants. There is no law in this country that cites and compels the people to do anything. It's the law is our mere creature. Everything's our mere creature. Except, God.
Mm-hmm.
When you're the creators of the Constitution, that's the supreme law of the land. It's our creature. Congress is our creature. The president is our creature. Those judicial courts are our creature. I got all the case law on it. Same way it's in the state. Same thing. Everything's inferior to us. That's why it's so nuts. The disease of being ignorant of the law. Look what happens. it would seem impossible.
The zombie apocalypse.
Yep.
Nothing is as it seems. Everything is a lie.
Yeah, it's all
Yeah.
fraud. I'd love to say that in court one time, just see what they say. Is there anything here that matters, especially relating to power and jurisdiction, that's not fraud?
Yeah.
Fraud voids everything. It's always been recognized in this country. There's supposed to be protecting us from it. It's in the state and federal rules for relief from, judgments, orders, and proceedings. I got massive case law on fraud because that's why I saw it. What isn't fraud? Amounts to any trick that mankind can devise. And the law abhors fraud. Go on and on. I did massive research on fraud. And I know basically you're on the right track when you go into court. If you can make them judges basically go silent